Vamos a seguir adelante. Seguimos adelante con una mesa muy interesante. La dejaba más o menos entrever Javier en nuestra conversación. Es la mesa de Allen Overy sobre Acquisition of Awards, Market Trends and Challenges. Va a ser en remoto, salvo nuestro moderador, que está aquí ya presente, quitándose el reloj como buen profesional de los moderadores para saber el tiempo que tiene por delante. Antonio Vázquez Guillén, Head of the Litigation and Arbitration Department in Spain and Co-Managing Partner of Allen Overy in Spain. Si te parece, yo creo, por no repetirlo yo, Antonio, presentas tú directamente a la gente que te va a acompañar en esta mesa virtual.
Muchísimas gracias,
bienvenido.
Fede. Muchísimas gracias. Buenas tardes a todos. Bienvenidos en inglés, que va a ser esta sesión. Good afternoon, ladies and gentlemen. It's a pleasure to be here today. Before I start, I would like, first of all, to give a huge thank to Asociación Europea de Arbitraje and its leader, Javier Iscar, for inviting Allen Overy to participate in this fantastic event today. But also, I would like to congratulate her and Sonia Hernando for the outstanding contribution that they've made. I think, honestly, that we need to welcome those who have new, fresh ideas. And not only that, but they are able to enforce them, execute them, and make that happen despite the difficult circumstances. Today, I think we should celebrate that. And I think we should celebrate it because it's a great news for the arbitration as a whole, and for Madrid and Spain as brands for the international market. So thank you very much, and congratulations, Javier, Sonia, and the Asociación Europea de Arbitraje. It's a real pleasure for me to be here today and facilitate this panel with great panelists that I will just right away introduce. It's really, particularly privileged, I feel. And I'm going to introduce them without any further delay. So I can see them in the screen here. First, I can see Jas Panifatemi. Jas is a partner at the Sherman Sterling law firm based in Paris. She's the head of the Global International Arbitration Group and the head of the Public International Law, as well as the energy sector at Sherman Sterling. She's counsel and arbitration, especially focused on investment protection, oil and gas, and general commercial. Jas is also the vice president of the ICC, International Court of Arbitration, and a member of the ICSID panel of arbitrators. She regularly teaches at Harvard Law School, Yale, and Le Sorbonne in Paris. So, buenas tardes, good afternoon, Jas, and welcome.
Hello, Antonio.
Thank you. Second, we have Peter Griffin. You can see on the right-hand side of the screen, Peter is the founder and director of Slaney Advisors. Slaney Advisors is a company devoted to the monetization of arbitral awards. It's really impressive. Peter has been participating in transactions regarding monetization of awards in the region of more than $11 billion. So you can imagine he is a real player of the industry we're going to talk about. Before that, before being a Slaney Advisors, and this is important as well, he was a litigator. He was a litigator in Paris, in London, and in New York as well. So he will know what he's talking about today. And then third, last, we have our great friend, Jeff Sullivan. Jeff used to be a partner at A&O. He's a partner at Gibson, Dunn and Crutcher. Jeff's practices focuses mainly in energy and infrastructure. He's counsel and lead advocate in commercial and investment treaty arbitrations under all the main rules, ICC, LCIA, SCC, UNCITRAL, and ICSID. And he is a dual qualified lawyer admitted to practice both in Washington, D.C. and England and Wales. So Jeff, good afternoon, and welcome as well to this panel.
Good afternoon, Antonio.
And I hope you can see me all right, because sometimes the image is here interrupted, but I hope you can you see me well? Yeah, okay. So perfectly. Now let's speak about the format. What we're going to do today is to have a very quick and dynamic format dialogue between the three of our panelists. I've really encouraged them to interrupt each other, to disagree or agree, to add any points to the key points that we're gonna be discussing. What is the topic today? Investment state arbitration awards have become as a new and very dynamic asset class for those seeking new sources of yield, of revenue, of return. That yield, that return will depend very much on one key point: the ability to collect the amounts awarded for a given party. This industry has been growing over the last couple of years, and the purpose of this session is to talk about this industry, what are the market trends, and what are the key challenges. We're going to be mixing up, in a way, law, arbitration, capital markets, and all together within the economy. So it's a real impact of arbitration in the investment and the international capital markets. So with that introduction, may I kick off, Peter, with you as a key member of the industry, as I discussed before. Can you let us know how is the industry going? What has happened over the last 5 to 6 years that has given rise to this incredible growth in this industry? Over to you.
Thank you, Antonio. And I hope you can hear me. Okay.
We can hear you.
I would like to, first of all, thank you for inviting me on this panel and to say what a pleasure it is to participate with you and my esteemed colleagues, Jeff and Yaz. The pleasure and the honor is all mine.
Thank you.
I think, to answer your question, in a nutshell, there has been enormous growth in this market in the last 5 or 6 years. And I attribute that growth to 2 factors which have coincided. And if I may, to understand this in the context of international arbitration, we need first to look at the wider context. After the Great Recession of 2008 and 2009, we witnessed a historic transfer of debts, primarily bank loans, from the banks, which need to be rescued, over to private investment funds. And this took place in Spain, all over Europe, the United States of America, all over the globe, in fact. Now, as the banks recovered and there was less distressed debt portfolios for these funds to purchase, they began to look for other types of investment that displayed important similarities to a discounted bank loan. And they came across arbitration awards because there is also a debtor-creditor relationship, because the same types of management and recovery techniques can be employed. The loans and the awards can be collected in the same way. So they began to look at arbitration. And then the second factor occurred simultaneously, which was the narrowness of the yield available in the traditional financial markets, be they bonds or be they equities. And so these funds began to understand that you could make a far greater profit investing in arbitration.
So, in a way, you're saying, Peter, that trend following the financial crisis in 08, 09, and the transactions over, let's say, non-performing loans and the like coming from the banks has given rise now to a new way of identifying distressed assets in the market. And these are distressed assets with a contingency, right?
Yes, I think, Antonio, there's an important clarification. The funds which came into this market were traditionally investing in distressed loans. That is not to say that there is anything now distressed about the sale of arbitration awards. They are sold at a discount, but I think it's no longer the case that the sellers of arbitration awards are distressed in any way. They make a simple commercial assessment that it's sensible for them to let somebody else take the award through to collection.
Okay. I think that's very clear. So maybe that connects with another question for Yas, and it would be that trend that Peter has identified, those funds looking for those type of investments, do they apply equally to what we would say investor state awards under ICSID or antitrust rules, for example, or they also apply to commercial arbitration awards? In your view, in your condition as Vice President of the ICC that you know well, Yas, you think it applies equally the same, or is there a difference? Or how do you see that?
Thank you, Antonio. I think that there's a difference. Commercial arbitrations tend to be enforced more easily because simply can enforce against assets of private parties. The figure that we hear often is 90%. I hope you hear me because there's an echo.
Yeah, we hear you well.
Okay. So the 90% enforcement rate seems to be quite high. I don't have not seen empirical studies for that, but the assumption is that the enforcement of commercial awards is quite high. Now, I've looked at the recent ICC figures, and the most recent one, for example, for the first 8 months of 2020, out of 381 awards, there have been 35 cases of either setting aside or opposition to enforcement. This is 9%, essentially. And of these, only 3 were successful, which is 0.7. So you get a sense of ICC awards, which are quite strong. This may be due to the strength of the meticulous scrutiny that is exercised by the court. And year in, year out, you have the same figures. For 2019, it was about 2% of successful attacks on awards, either on setting aside or opposition to enforcement. And same thing, 1.5% in 2018. And we're talking about 600 awards. So you see that in commercial arbitration, it's easier to get an award recognized and satisfied. Now, if you look at investment arbitration and mostly investment treaty arbitration, there's a bit of more difficulty because the empirical studies are not that many. Institutions don't divulge a lot of figures. So what I have done actually is I've inquired with ICSID, but there's one source which is a great one. It's a forthcoming article by Emmanuel Gaillard and Ilya Mitra-Penevsky that will be published soon in the review, and that has been focusing on the entirety, the universe of published awards in investment arbitration.
Mhm.
So the lessons from that is that indeed there is the buying and selling is more interesting for investment awards because there's a higher level of uncertainty for the investor once they have prevailed. That said, there are policies, there are state policies. In annulment, for example, the study shows that 83% of the damage awards are challenged. This is 141 out of 170 awards. And you see that most states that are repeatedly sued do challenge. That's Argentina, that's Venezuela, Ecuador, and Russia. When you look at enforcement, you do see policies. So some states have a policy of never paying, always challenging. That would be Russia. And some other states, on the other hand, do not challenge. And the study shows, for example, that Bolivia has never sought to challenge an adverse award and has satisfied its awards. So you see that some states are respectful of the legal obligations and others tend to challenge more. And a couple of more interesting figures. 50% of awards or damages have been paid. So that's 85 out of 170 damage awards. Of those, only 26 were satisfied without an annulment proceeding, which shows again that states tend to challenge often, not always successfully, but then when they do satisfy, it's after the process of going through an annulment proceeding. And the final figure that is also appearing in this very interesting study is that 40% of the cases, enforcement had to be undertaken. So that is 67 of these 170 cases. So this really shows that there's potential for this market in investment treaty arbitration. Again, disregarding policies of state, you see that there's a general trend. And if only 50% are satisfied, regardless of policies, you see that there's a lot to be done.
Yeah, that's absolutely clear, Jas. I don't know, Jeff, if you can also endorse that position or not, but I mean, obviously what we see following the figures that Jas has provided us with, there's a huge difference in terms of setting aside applications, in both cases commercial compared to investment treaty, and equally opposition to enforcement. It's a big difference. So probably in that difference is where the market opportunity lies. Right, Jeff? I don't know if you have a view on that.
No, I completely agree, Antonio. Those are very interesting statistics. Yeah, as I was trying to write some of them down, actually. Because,
I saw you.
I haven't heard those before. Thank you for the sneak preview. You know, and of course, there's sovereign immunity issues with states that you don't have with commercial awards as well, which is one of the reasons it's more difficult to enforce. So that's another reason I think that there's a bigger market probably for this industry with investment treaty awards.
Okay. I mean, connected to that, Jeff. Sorry, Jeff, Peter, go ahead, please.
If I may, there's also a reason coming from the buy side. So many of these funds, the enormous ones, would hold the bonds issued by sovereign states, and they might have a portfolio of them. But as we all know, the ability of a single bondholder to unilaterally take action against a sovereign is almost unrealistic. In these days, you have collective action clauses that require bondholders to act collectively.
Right.
So some of those bondholders are on the lookout for awards against the same sovereign because it gives them another quiver in their relationship with the issuing state. Okay. So there's difficulty on the award holder side and needs on the buy side.
Okay. Now that I've got you, Peter, maybe one follow-up question here. Now that we tried to describe the market, so clearly we see that it's leaning a bit more towards investment state awards as opposed to commercial. How about the geographic-wise, in terms of, is this more a business in Anglo-Saxon countries, i.e. UK, US, or do we also see that in continental Europe as well?
I think it's a global business, Antonio. We talking from our own experience, have been involved in awards monetizations in North America, Western Europe, the Middle East, North Africa. I think it's global. I think just perhaps because of the genesis of this industry, some of the funds that are better known were set up in the United States, but they are all now operating on a global basis.
Okay. Maybe one key question, many of the people that may be attending this event may be counsel for claimant or defendant, and the question goes to you, Jeff. What happens when you come with the award that recognizes an economic right for your client, and that's the end of the arbitration as such. But then obviously there's a new phase, which basically is to succeed at the application to set aside annulment and or enforcement, if the case may be. My question to you is, when does an award holder decides, what are the drivers for him to decide, I want to sell my right?
So I think there are probably 3 or 4 key drivers for award holders when they think about whether they want to sell their award or undertake enforcement themselves. First, as Peter pointed out in his opening remarks, in many ways it's a commercial decision. These aren't distressed claimants in most situations. They're well funded themselves, but they may take the view that they'd rather have an immediate payment, less than the award value, but take that immediate payment and let somebody else take on that enforcement risk that Yaz discussed. There may be an annulment proceeding or some sort of appeal, and potentially lengthy enforcement proceedings. So that's a commercial decision. I also think in many cases litigation fatigue comes into play. Very often claimants are not in the business of getting involved in major arbitration proceedings. They tend to take a long time, and by the time they get their award, we then as counsel often have to tell them, well, you're not done yet. You've got another few years to go before you can actually collect. And at that point they say, well, how do we find a way out now? So they can get back to their day jobs. And then, the other thing, of course, is the buyers of these awards tend to be experts in enforcement. As Peter mentioned, a lot of them have, particularly in the investment treaty context, they'll have been engaged with sovereign governments, negotiating bond instruments, bond debts, and so they'll be very experienced in pursuing these sorts of enforcement procedures against states. So for the seller, it's let the experts handle it. We'll take our cash now and pass on the risk to somebody else.
Okay, and then we would like to know from Peter probably the buy side. I mean, what is the profile of the, let's say, the player the seller has to look for, and when do we have a match? I mean, I would like to know a little bit about those funds. What are they looking for? How do they identify the market and the right investment deals?
Oh, I think, if I may just, sorry. So the funds that we deal with are all regulated financial institutions. I think that's very important for people to know and understand. This is a new market, but it's a new market that is being developed by very experienced, reputable, regulated entities. I think the profile of the funds can vary depending on the particular characteristics of the arbitration award. But broadly speaking, we have the population, if you like, of investors would be credit investment funds, what are called special situations funds, and in some cases, emerging markets funds. Because if the award in question involves an emerging market, then they would be the natural investor.
But so that I understand here, the question would be for you, those funds typically only do monetization of arbitral awards, or do they also do, I don't know, I mean, judicial decisions or other sort of distressed assets?
Oh, I think they have a very wide palette of investments that they are capable of undertaking. I'm not aware of any fund that is narrowly focused on arbitration awards against sovereigns.
Okay.
This brings me to sort of a broader point. I predict that this is kind of the tip of the spear. And we will see activities of these financial institutions in other kinds of litigation as the years pass.
So you think this is expanded somehow, right?
Absolutely, I think it is expanded. Look, I think, if I may, the traditional view of litigation was that of a cost center, where the claimant had lost something and then had to spend more money to try and get it back. That is now the new view, is that this is an asset class, and like the asset, you can monetize it at various different stages in its life.
Okay.
You can have a claim and sell it. You can make more money by selling it once you have an award. You can make even more as you get closer to the final claim.
Right. Okay, no, we're really focusing in this session exactly, we are just avoiding to talk about third-party funding in the middle of the claim, but just focusing on the acquisition of awards. And here maybe I will go to Jeff and Jas now in your condition as counsel. Maybe Jeff, you can let us know, how do these transactions work? I mean, what is the underlying, let's say, list of rights and obligations for both parties in order to assign the economic rights derived from these awards, in your experience and what you've seen in the market?
Sure. So I think there's a couple of different ways that these transactions are structured. In some cases, what you'll see is a pure assignment of the award. So it's a sort of old-fashioned transfer of an asset. And the buyer takes all the rights under the award, the seller sells all its rights, and they go their separate ways. That's probably less common. I think at least, and Peter can probably add some detail on this, but at least in my experience, that's less common. In some cases, you'll see the sale of the company itself. If the entity that owns the award is a special purpose vehicle and doesn't really have any other assets, they can actually just buy the company that owns the award. You then remove some of the legal issues around what we call in English law champerty. There are some certain jurisdictions which prohibit the sale of awards. And then the third way you sometimes see this done is a form of litigation funding. I know we're focusing more on the sale of awards, but they are sometimes more as a funding arrangement where the buyer essentially funds the follow-on enforcement proceedings or appeal proceedings, and then has rights to collection rights essentially. And in those cases, obviously the seller is more involved in the process going forward. They're not completely removed.
In that case, you mentioned when you buy the SPV, isn't there a risk for the buyer? I don't know if you've seen that, or Peter as well, in the sense that you are buying a company. It's a special purpose vehicle. It holds nothing else but the claim, or the award in this case, but it could have liabilities or other things that you may not want to take you with, right?
Yeah, so you're right. You're absolutely right, Antonio. In those cases, there's a lot more work to be done by the buyer to make sure that the company they're buying is free of liabilities, that the transaction itself could be much more complicated in terms of the warranties that are required by the buyer from the seller. That's a very much more of a traditional M&A transaction, and so that is more work, I think, in the transaction process. Once you get through the transaction process, it's probably a bit cleaner for both parties, because then you have the buyer owns the company that owns the award, and the seller is essentially removed from the process.
Right. So that connects exactly with a question I would like to raise today as well, which refers to the role of counsel here in that transaction. And I mean, of course, counsel for buyer, counsel for seller. Maybe, yes, you can let us know what you know about what is in that transaction that Jeff was describing in any of the different options, funding or acquiring the SPV. Is there a specific role for counsel in the sense I mean here that what you're buying is a legal contingency at the end of the day? I mean, the right person to do the assessment, if you want to assess to the client, is precisely the lawyer, right? To evaluate likelihood, level of risk, and so on and so forth. So how do you see role of counsel here?
There's a number of elements that will be taken into account, and without any specific order. For example, whether the award will be challenged. And we've seen that in investment with arbitration, that's a pretty serious risk. So the question is whether the chances of success of that challenge. And that is where the lawyer will have an important role to play, because you can anticipate the seriousness of the argument. Then you have the amounts that are sought, that is true also in the pre-award stage, the sale at the pre-award stage, and the reasonableness of that amount. You have the benefit in selling the award rather than enforcing it. And I would say, based on my experience, the reverse situation is also true. The appetite of enforcing as opposed to selling. And I remember that when we prevailed against the Russian Federation in the Yukos case, we had over 50 billion awarded to our clients, the majority shareholders of Yukos. There was an appetite to enforce. There was not an appetite to sell. So it really depends again on who's the respondent, and who the claimant, and also the context around it. Of course, the identity of the buyer will be important in whether they have experience in this sort of transaction and claim. The identity of the respondent is important. As you've seen, some states are very resistant. If you buy in order to enforce the proceeding, then you know that Argentina, Ecuador, and so forth, for example, will be challenging more. Of course, the pricing and potential discount that will be entertained, the appropriate monetization arrangement. And here I've been in situations where our clients being tempted by selling, in the end ended up not doing it because the arrangement was not satisfactory and the discount may have been too large. And in the event of partial purchase, also how much control the buyer will end up having, and that is an important factor to keep in mind as well.
Mm-hmm. Any other point here, Jeff, you would like to add on those which Jas has described very well? But I mean, I think it is really, really important, the role of counsel here, as Jas is describing.
Yeah, I mean, I think that's absolutely right. The one other thing I suppose to mention is the role in the process of the transaction itself. The sellers usually would like to have access to counsel. So if I was looking at a seller looking at an award that a $50 billion award that Jas had won for her client, I'd want to speak to Jas and find out what she thinks the risks are, and help the buyer with their due diligence. And so you very much come involved in these discussions, as counsel, doing the due diligence either on the buy side or the sell side, and I've done that on both sides in various cases, and it's quite an interesting thing to see for us litigation lawyers.
But probably here we should all be aware. Oh yeah, Peter.
I just wanted to add to Jeff and Jas's point. I think that going forward, the arbitration lawyers will have to be mindful that their work product may be the subject of a data room in a due diligence exercise. I'm very thankful that my days as a lawyer are now over, but it is, I think, importantly, we're going to have to have that mindset as we maintain our documentation and carry out our roles as litigators. That this might be sold at some point.
Yeah. That is exactly the point I was going to make, right? So following what Jas and Jeff have said, your notes, your minutes, or your draft materials may end up at a data room one day and be reviewed. So that's a very good point, and watch out for counsel in the arbitration and what happens next. Critical point, and that connects, Peter, with the next one, which is, I think, the million-dollar question for you. You can imagine. All of us will want to know, what about the amount? What about the value of the transaction? We need to know, let's just give us an example, Allen Overy, an award holder for 100 million euro. What do you think would be the right value in that transaction, and what are the key factors that are taken into account in the buy side in order to make the deal happen?
I'm afraid my screen blocked as you were asking, but let me answer what I think you asked. I think in terms, well, first of all, what are the factors that the buy side look at? I think first and foremost, they will look at the award. They will look at the award debtor. And at this point, they will look to the award debtor's bonds, if there are issued bonds in the market. And that the price of the bonds forms a benchmark against which you then calculate the pricing for the award. You're always going to pay less for an arbitration award than a bond because it's illiquid, it's expensive to trade, and many other premium, negative premium. The next thing as an investor that you will look, and this is interesting from a practitioner's perspective, is the interest rate, if any, that has been awarded. That can be a critical positive or negative in coming up with the price that you would pay for your award. We all have seen cases where enormous interest has been granted, and that will be attractive to an investor. But similarly, we've seen cases where there has been no interest awarded at all. So you're in a kind of negative, declining value from day one. You will then look at the amount of damages granted. Mm-hmm. This is to Yaz's point. For investors, we call it the glass ceiling. There are simply awards that are too high to be able to be traded. They are for too much money.
Okay.
You can't buy a $50 billion award at 50 cents on the dollar. Nobody's going to spend 25 billion. So.
Sorry to interrupt you here, Peter, but that connects with a question which is there practice that there are some investors together that syndicate the situation and buy together the award in those big tickets ones?
Yes.
And not just one?
Yes, there are. But it's not very common, but we have seen that. And I think we're going to see it more. But not really for the reason that you might think. It's less because they want to team up to buy huge awards. And it's more about spreading their risk by buying many awards. So when you look at all of these factors, you can come up with a price, but it's very difficult to give any meaningful number in this kind of general context.
Okay, all right, fair enough. Okay, maybe we should connect now a little bit more with the procedure. And Jeff mentioned before this Champety and maintenance doctrine, which is something that I would like to know if that would impact at all in the proceedings. Obviously, the proceedings have ended because we're looking at the arbitration award, but they can be an application for annulment or even the enforcement. So I don't know, Jas, if you could let us know, is there an impact? Is there an element of a risk for the buyer of that Champety being applied or not? And second, is there a risk? Is there an obligation to disclose that transaction eventually to the ad hoc tribunal, for example, at exit in the context of an annulment?
Jeff referred to the Champety doctrine. I mean, there is the risk to the extent that if a jurisdiction prohibits it, you have to be careful of that risk. When it's not the case, you still have to be aware of the threshold that Champety can be constituted when you have a threshold of impropriety, right? So meddling or disproportionate control by the buyer or and corrupt or fraudulent intent. So these sort of conduct you have to be careful about. The FG Hemisphere versus Congo case is a good example that's often cited in relation to the Hong Kong court, first having said that it may constitute property, and then in the end having decided that that was not the case. So a judge will presumably look at the factual matrix and the legal matrix of the transaction. Regarding ICSID and whether, and we're really looking at the ICSID very specific mechanism where annulment is sought before an ad hoc committee, which is appointed by ICSID itself. It's not a domestic court, it's really an ad hoc committee within ICSID, which is the World Bank arbitration. The simple answer is no. The simple answer is that procedurally there's no requirement to disclose the existence of the sale of the award. Now, and of course, that's quite different from the assignment of an ownership, because if there is an assignment of ownership between the arbitration and the annulment proceeding, then that may raise issues, contentious issues. But to the extent it's just the award that we sold, there normally should not be any difficulty. Now, I would distinguish between the lack of requirement as a legal matter and the appetite of arbitrators to be told and have a disclosure as a matter of transparency of simply who is the economic interest behind a proceeding. So again, it's not an obligation, it's not a legal obligation, but I think that where we're going, there will be an appetite of knowing. So a disclosure
Okay.
for reasons of transparency.
All right. I see Jeff nodding here. I don't know if you're in agreement with that.
Yeah, no, I completely agree. There's as Jas mentions, there's certainly a movement towards transparency, and I think tribunal members do want to know if there's been a change in the economic interest. But I also agree with Jas that there's no legal requirement to disclose.
Okay. So that leaves plenty of room for these transactions, which is important. I'm mindful of time. I've been told we've got 5 more minutes, a couple of minutes ago. So I would just raise the very last question, and I would like each of you to address it. It's more conceptual, right? And it's in the interest of understanding the possibilities of the arbitration sector as a whole. And my question to you would be a bit, what do you think, how does the future hold? What does the future hold for this industry? And whether the post-COVID era opens up new doors, or on the contrary, it's a break for that industry? How do you see that? I mean, I would like each of you to address it. I don't know, whatever order. Maybe Peter, you want to kick off?
Sure. I think that the impact of this development will be positive in many respects. I think it will improve access to justice because it will give claimants a real timeline, firm timeline to monetization, which, particularly when they have sovereign claims, they don't have. And second, I don't want to say a second point. I think that we will see the day coming when, because of these financial institutions getting involved, there will be pressure put on sovereigns to disclose their arbitration indebtedness along with the rest of their sovereign debt. And they will no longer be allowed to play one game on the sovereign bond market and get where arbitration, and that will lead to better behavior by the sovereigns.
Okay, that's a very good forecast. Let's see if that is what happens. Maybe, yes, you agree with that? Or any other views?
Peter said it all. I would like to add one point to Peter's access to justice. I agree with Peter. And if you look at certain specific circumstances, such as the consequence of plantea, and really where the EU law is going, you see that certain investors, such as the Mikulas, having gone through years of enforcement, here and there in the US, and encountering the difficulty that the Commission will come out and say this is illegal, this is against EU law, and so forth. Individual investors such as the Mikulas don't have the power, don't have the strength to enforce an award after having fought for so many years. So having an institution that can back up and can help them enforce, I think is a welcome development, really, because that does allow access to justice to the very end, because it's not enough to have the title. You want that title to be satisfied.
Okay, so you also see a growing industry here. And Jeff, last but not least, yourself.
I agree with both of my co-panelists. I think it's a growth industry, and I also agree that it's good for the industry. And access to justice is a very good point. And I think the other thing to remember is some of the concerns that have been raised around litigation funding don't really arise in this context. I don't think we should put it in the same bucket, because here you already have an award. There's no concern about meritless claims being brought because they're funded. Here you've already been through the process. You've got a judgment, and then what you're actually promoting is compliance with awards, which promotes the rule of law, which is a good thing. So I think that's one last point to make on access to justice.
Okay, well, that was fantastic. I think it's now time to wrap things up. I see here a growing industry. Our last message is everyone to be aware of these great sort of new roles to play in the buy side as funds, in the sell side as companies, counsel for any of both, or arbitrators. Ultimately, it's a great news for arbitration and the growth of the international investment. In the absence of a proper round of applause, I would just ask everyone to join me in thanking Jas, Jeff, and Peter for your time, and thank you everyone for the attendance. Thank you.